wondered what happens when a sale deed is cancelled? It's not as simple as tearing up a piece of paper. The sale deed is a critical legal document that transfers ownership of property from one person to another. But what if there's fraud, misrepresentation, or a fundamental error? The Supreme Court of India has laid down crucial judgments that shape the rules around cancelling sale deeds. And understanding these can save you from a legal nightmare. In today's video, we'll break down the latest Supreme Court rulings on the cancellation of sale deeds, explain what you can do if your rights are violated, and provide some actionable steps. Stay tuned because this could protect your property rights. Before diving deep, let's quickly summarize what we'll cover. First, what is a sale deed and when can it be cancelled? 2. Key Supreme Court judgments on sale deed cancellation. 3. Steps to take if your sale deed is wrongfully cancelled. 4. Recent updates and legal facts you should know. Now, let's explore each of these points in detail. A sale deed is more than just a document. It's a legal instrument that seals the transfer of ownership of a property. When a sale deed is executed, it's assumed that everything is in order: consent, consideration, and legality. However, this isn't always the case. A sale deed can be cancelled under certain circumstances. And here's when. First, fraud or misrepresentation. If the deed was signed based on false information or deception, it's ground for cancellation. For instance, if the seller misled the buyer into the property's ownership or legal status, the deed can be invalidated. 2. Coercion or undue influence. A deed signed under pressure or coercion is not legally binding. The courts can nullify it if proven that one party was forced into signing. 3. Non-compliance with legal requirements. Missing signatures, incorrect details, or failure to register the deed can make it void. 4. Mistake of fact or law. Errors in the deed's details or misunderstandings of legal implications can be reasons for cancellation. Let's look at some recent Supreme Court rulings that clarify these grounds. Here are some judgments regarding cancellation of sale deed. First, S. Vanitha versus Deputy Commissioner. This judgment emphasized that a sale deed executed through misrepresentation or fraud is null and void. The court stated that any property transfer without a genuine intention is liable for cancellation. 2. Subramani versus R. Paneerselvam. The court ruled that a sale deed obtained through coercion or undue influence lacks legal standing. It reaffirmed that free consent is crucial in property transactions. 3. Balakrishna Dattariya Galande versus Balakrishna Rambarose Pawar. In this case, the court highlighted that an unregistered sale deed is not enforceable by law and can be easily challenged. 4. Vidya Devi versus Prem Prakash. In a recent decision, the court reaffirmed that any sale deed executed under fraudulent circumstances, where the seller has no clear title or the transaction was marred by deceit, can be cancelled. The judgment also emphasized the importance of thorough documentation and proof to establish claims of fraud or misrepresentation. So, what can you do if you believe your sale deed has been wrongfully cancelled or you're facing challenges with property disputes? First, consult a lawyer. The first step is to get legal advice. A property lawyer can help assess whether the cancellation was legitimate and guide you in the best course of action. 2. File a civil suit. If fraud, misrepresentation or coercion is involved, you can file a civil suit seeking to cancel the deed and reclaim your property. 3. Seek arbitration or mediation. Recent rulings such as the Bhimrao N. Kale case show that arbitration is now a valid route. Mediation can resolve disputes faster and with less friction between parties. 4. Obtain a stay order if there is an immediate threat to your property rights. A stay order from a court can prevent further legal action against you until the dispute is resolved. 5. Document everything. Keep records of all communications, legal notices and property documents. This evidence is crucial in court. The landscape of sale deed cancellation is evolving. One recent update from the Supreme Court is that all disputes related to property deeds should first explore arbitration, emphasizing faster, more cost-efficient dispute resolution methods. Moreover, recent amendments to the Specific Relief Act underline the need for transparency in property transactions, making it harder for fraudulent sales to slip through the cracks. Let's quickly recap what we have discussed. First, sale deeds can be cancelled due to fraud, coercion, mistakes or non-compliance with legal procedures. 2. Recent Supreme Court judgments stress the importance of genuine consent and legal compliance. 3. If your rights are violated, consult a lawyer, file a suit, consider arbitration and secure evidence. 4. Stay updated on the evolving legal landscape regarding sale deed cancellations. It's essential to know your rights and legal pathways available if you're ever caught in a dispute. If you found this video helpful, please like, share and subscribe to stay informed on all legal updates. And if you have any questions, drop them in the comments below. We'd love to hear from you. Bye.